Welcome friends. Today I am discussing compensation and cost in criminal procedure code. The function of criminal code is to punish the offender, while that a civil code is to make the power the wrongdoer compensate for the loss or injury or cost to be aggrieved party. However, if these two procedures can be combined without affecting the criminal and civil process, it would be just an expedient to do so. It would save time and money to seeking remedies in two different codes. Section 357 CRPC incorporates the idea to an extent and empower the court to grant compensation to the victim and to order the payment of cost of the prosecution. Section 357 reads as follows: when a court imposes a sentence or fine or a sentence including a sentence of death of which the fine from a part, the court may, when passing judgment, order the whole or any part of fine recovered to be applied. A. In defraying the expenses properly incurred in the prosecution. B. In the payment of any person of compensation for any loss or injury caused by the offence, when compensation is the opinion of the court recoverable by such person in a civil court. C. When any person is convicted of any offence for having caused the death of another person or having abated the commission of such an offence, in paying compensation is to be person who are under the Fatal Accident Act 1885 entitled to recover damages from the person sentenced for the loss resulting to them from such death. When any person D. When any person is convicted of any offence which includes theft, criminal misappropriation, criminal breach of trust or cheating, or having dishonestly received or retained or having voluntarily assisted in disposing of stolen property, knowing or having reason to be believed the same to be stolen, in compensating any bona fide purchaser of such property for the loss of the same, if such property is restored to the possession of the person entitled thereto. Number 2. If the fine is imposed in a case which is subject to appeal, no such payment shall be made before the period allowed for presenting the appeal has been elapsed, or if any appeal be presented before the decision of the appeal. When a court imposes a sentence of which fine does not form a part, the court may, when passes judgment, order the accused person to pay by way of compensation such amount as may be specified in the order to be person who has suffered any loss or injury by reason of the act for which the accused person has been so sentenced. Class 4. An order under this section may also be made by an appellate court or by the High Court or Court of Session which exercising its power of revision. Class 5. At the time of awarding compensation in any subsequent civil suit relating to the same matter, the court shall take into account and sum paid or recovered as compensation under this section. Under the above section, compensation can be awarded irrespective of whether the offence is punishable, which with fine and fine is actually imposed, but such compensation can be ordered only if the accused is convicted and sentenced. The compensation should be payable for any loss or injury, whether physical or pecuniary, and the court shall give regard to the nature of the injury, the manner of inflicting the same, the capacity of the accused to pay, and other relevant factors. Under subsection 1 of section 357 CRPC, compensation could be directed to pay only if the accused is punished with a sentence of fine or with some other sentence of which fine form part, and secondly, it could be directed to paid out of the amount of fine recovered. Consequently, the amount of compensation could be no case exceeded the amount of fine, and the quantum of fine would again depend upon the limit up to which fine was awardable from the particular offence and also upon the extent which the court had power to impose fine. However, compensation can be granted under subsection 3, section 357 quite liberally and without any such above mentioned sentence. But it will be noticed that the liberal provision of the section 3 clause 3 are applicable only if sentence fine is not imposed. If the sentence fine is imposed, compensation can be awarded to be paid only out of the amount of fine as mentioned in subsection 1 of section 357 CRPC. The object of section 357(3) is to provide compensation payable to the present persons who are entitled to recover damages from the person sentenced even though fine does not form part of the sentence. It is rather surprising that the power of magistrate of judge to grant the amount of compensation under section 357(3) is unlimited. A magistrate of the second class, for instance, has power to pass a sentence of fine not exceeding 1,000. But if the same magistrate, instead of imposing a fine, awarded compensation under section 357(3), he can do so without any apparent limit, and the amount of compensation in such a case can even be 10,000 to 50,000 depending on the loss or injury to the victim. Further, unlikely subsection 1, section 3 does not make any provision for the payment of costs incurred to the prosecution. For sustaining an order directing expenses to be paid to the state, clause A of section 357(1), there must be a substantive sentence of fine. In the absence of such sentence of fine, no direction under clause A can be made. Clause B of section 357(1) deals with payment of compensation to the very person to whom any loss or injury has been caused as a result of the offence committed against him or his property, and when compensation recovered by such person in a civil court. The question of recovering fine and compensation has been examined by the Supreme Court. It was open that in the default to pay compensation, the accused shall suffer simple imprisonment. Such as order be issued under section 357(1) inasmuch as it alone empowered the court to order fine. If the compensation ordered in terms of section 357(3) is not paid, it could be ordered to paid under section 421 of the code. The court is a subsequent decision held the compensation order under section 357(3) could be realized as a fine in terms of section 431 read with section 64 IPC. The court, while imposing fine, will be competent to include a default sentence to ensure payment. Thus, the distinction between fine under section 357(1) and compensation under section 353 came to be examined again in K.A. Abbas versus Sabu Joseph 2010 SCC. The question was whether in default the payment of the compensation order under section 357 subclause 3, a default sentence can be imposed through fine and compensation are distinct. It is fact they can be recovered as a fine. In R. Mohan versus A.K. Vijay Kumar 2014 SCC, the Supreme Court again got an opportunity to examine the question. Section 431 provides for recovery of any money other than fine payable by virtue of any order made under section the code and the recovery to which is not otherwise provided of fine for. Thus, compensation can be effectuated by section 431, which lays down that money can be recovered as if it is fine, and proviso to section 431 says that section 421 could be relied on the recovery the court reasons. In section 431 of the court put compensation order to be paid, the court on a part with fine so far as made a recovery is concerned, and there is a reason why the court cannot impose a sentence in default of payment of compensation, as it can be done in case of default in payment of fine under section 64 IPC. Under class C of section 357(1) enable the court to direct the whole of any part of the fine recovered may be applied in paying compensation to the person who are under the Fatal Accident 1835 entitled to recover damages from the person sentenced from the loss resulting to them from the death of person whose heirs as decided in the Act of 1855 they claim to be. In awarding compensation, the court should not first consider the compensation ought to be awarded to the heirs of the deceased and then impose a fine with a higher than compensation. It is duty of the court to take account the nature of the crime, the injury suffered, the justness of the claim for compensation, the capacity of the accused to pay, and other relevant circumstances in fixing the amount of fine or compensation, and the Supreme Court has urged the court to exercise the power under section 357 liberally. It has also been held that if there are more than one accused, they may be asked to pay an equal term unless their capacity to pay varies. The payment may also vary depending upon the act of each accused. The court has also opened the reasonable period from the payment of compensation, if necessary by installment, can be given. The court may enforce the order for imposing sentence in default. It is only appropriate to direct payment of compensation to the dependent of the victim by the accused who has capacity to pay in case of murder. It is only fair the proper compensation should be provided for the dependent of the accused. The Supreme Court in Ankush Shivaji Gaikwad versus State of Maharashtra 2013 SCC have had an opportunity to deal with the often forgotten victim compensation. It is case wherein the appellate conviction under section 302 was inherent to one section 304 part 2, including the punishment of life imprisonment to 5-year rigorous imprisonment. The court throughout to proper to examine the history of the compensation in India and abroad and emphasize that inappropriate and relevant thus. Applying these tests which emerge from the above cases to section 357, it is apparent to us that the provision confers a power coupled with a duty on the court to apply its mind to the question of awarding compensation in every criminal case. We say so because in the background and context in which was introduced, the power to award compensation was intended to reason the victim that he is or she is not forgotten to the criminal justice system. The victim would remain forgotten to the criminal justice system despite the legislature having gone so far as enact a specific provision relating to victim compensation. Court choose ignore to provision altogether and do not can apply their mind to the question of compensation. It follows that unless section 357 is read to the confer an obligation to the court to apply their mind in the question of compensation, it would defeat the very object behind the introduce of the provision. Incidentally, the court did not grant compensation, nor did it remand the case or to the lower court for the awarding compensation. In 2009, section 357A was added to the code. It came into an effect for 31 December 2009. Enacted thus: every state government is coordination with the central government shall prepare a scheme for providing fund for the purpose of compensation to the victim has depending who have suffered from loss or injury as a result of the crime and who require rehabilitation. Whether a recommendation is made by the court for compensation, the district level service authority or the state legal service authority, as the case may be, he shall decide the quantum of compensation to be awarded under the scheme referred in a subsection 1. If the trial court at the conclusion of trial it is satisfied that the compensation awarded under section 357 is not adequate for such rehabilitation, or where the case and is acquitted or discharged and the victim has to rehabilitate, it may make recommendation for compensation. Where the offered is not traced or identified, but the victim is identified and no trial take place, the victim has or his dependent may make an application to the state or district level service authority for award of compensation. On receipt of such recommendation on the application under section 4, the state or district legal service authority shall, after the inquiry, award adequate compensation for complying the inquiry within 2 months. The state or district level authority, as the case may be, to alleviate the suffering for the victim, may order for immediate first aid facility and to medical benefit to made available free of cost on the certificate of the police officer not below the rank of the officer in charge of the police station or a magistrate of the area concerned, or any other interim relief as the appropriate authority deem fit. Victim compensation scheme has thus been strengthened to assigning role in the state government and legal service authority in its implementation. The scheme is made available to the victim irrespective of the customs of the prosecution. A few states having already initiated action, others are on the way. Protection of the victim has now been enhanced by the incorporated of section 357B and 357C, which run as follows. 357B. The compensation payable by the state government under section 357A shall be addition to the payment to fine and victim under section 326A of 3 or section 376D of the IPC. 357C. All hospital, public or private, whether run by the central government, the state government, local bodies or any other person shall immediately provide the first aid or medical treatment free of cost to the victim of any offence covered under section 326A, 376, 376A, 376B, 376, 376D or 376E of the IPC, and shall immediately inform the place of the police of such incident. Successful complainant to get cost in non-cognizable case. In the connection with section 359 provide as follows. 359. Whether any complaint of non-cognizable offence is made to be court, the court, if it convicted the accused, may, in addition to the penalty imposed upon him, order him to pay to the compensation, order to pay to the complainant in whole or in part the cost incurred by him in the prosecution, and may further order that in default of payment the accused shall suffer a simple imprisonment for a period not exceeding 30 days, and such cost may include any expense incurred in respect of process fees, witness and pleader fees, which the court may consider reasonably. An order under this section may also be made the appellate court by the High Court or Court of Session when exercising its power of revision. It may noted that the court is empowered under this section to order the accused to pay the cost to complain in addition to the penalty. Section 358 incorporated compensation for wrongful arrest. Section 358 empowered the court to order a person to pay compensation to another person for causing a police officer to arrest such other wrongfully. The state read as follows. Whether any person causes a police officer to arrest another person, if he apply to the magistrate by whom the case is heard that there was no sufficient ground for causing such arrest, the magistrate may award such compensation not exceeding 1,000 rupees to be paid by the person so causing the arrest to a person so arrested for his loss of time and expense in the matter as the magistrate think fit. In such case, if more persons than one are arrested, the magistrate may in like manner award to each of them such compensation not exceeding 1,000 rupees as magistrate think fit. All compensation awarded under this section may be recovered as it were fine, and if it can be so recovered, the person whom it is payable shall be sentenced to simple imprisonment for such term not exceeding 30 days as the magistrate direct, unless such sum is sooner paid. Usually it is the police officer who investigates and makes the arrest and the complainant. If it all can be considered to have a nexus with the arrest, it is rather direct or remote. For applying section 358, some direct and proximate nexus between the complainant and the arrest is required. It has been held that there should be something to indicate that the information caused the arrest of the accused with any sufficient ground. There have been instances with the judiciary order compensation by the state to the pay to the victim because of the failure of the police to process prosecution in such a case. The police was asked to bear the cost of compensation against them filed by the victim of their illegal act. In other case, the High Court, in exercise of inherent power, ordered the complainant to pay compensation to the harassed defendant. In yet another, the complainant was asked to pay the cost to the government rather than to the defendant. This section does not make any express provision for giving an opportunity to the complainant or the concerned person to show that there was sufficient ground for the causing the arrest to made or to show cause as to why an order to pay compensation under this section should not be passed against him. However, looking to the consequences which are likely to follow him for the order of payment of compensation, the principle of natural justice would require that such an opportunity should be given to the complainant or other concerned person. This is some provision related to the compensation and cost. Some more provision in the CRPC I am discussing in the coming lecture. So please like, share and comment my channel. Thank you. Jai Hind, Jai Bharat.